I guess, main circumstances in which breach of confidence issues can arise. The first is where the client comes to you and somebody close to them, such as a friend, family member, spouse, lover, is threatening to disclose some kind of personal or private information. And the second, and perhaps the more exciting one, is where the client receives inquiries from the media and it's apparent from the terms of those inquiries that the journalist has access to something that they shouldn't. And I'll be looking at both of those. Primary remedy, of course, that the client is going to be interested in is obtaining an injunction to restrain the disclosure of the breach of confidential information, because that's obviously much better than allowing the disclosure to occur and then seeking damages afterwards. The first thing that you're going to need to explore with a client in a situation like that is the nature of the information that they're seeking to protect. And I think it's important at this point to demarcate confidentiality from some cognate legal areas. The first distinction I think we need to draw is between confidentiality and privacy. So, as most lawyers know, legal protection for privacy in Australian law is relatively limited. And there is a substantial degree of overlap between the kinds of information that might be regarded as private and the protection that the law of confidence can offer, but they are distinct. And I think the distinction is best summed up this way. We tend to think of private information in terms of the intrinsic characteristics of that relationship, whereas confidentiality has more to do with the way the information is treated. So think about it in terms of this example. If you're on the beach and a stranger comes up to you and takes photos of you in your Speedos, your bikini, most people would consider that to be a serious invasion of privacy. But it's almost certainly not a breach of confidence because there's nothing confidential about you and your swimmers. You go out and about in public that way and you're seen by hundreds of people on the beach, and that information doesn't have the characteristics of confidential information. I think the next distinction we need to draw, at least from the perspective of my practice, is between breach of confidence and the kinds of issues that that cause of action can protect and the law of defamation. And think about the distinction in this way. Is there any confidentiality in information which isn't true? One of the requirements for bringing a cause of action for defamation is that you need to be satisfied that the defamatory allegation or imputation about the client isn't true, because truth is a defence. So what recourse does a client have in a situation where they're worried about a potential publication of information about their personal life, or which they might regard as confidential, but some of the details of that information aren't true? This is something that's been explored in some of the English cases. There was a case called Khashoggi and Smith in the 90s where a High Court judge in England suggested a distinction between information which was untrue and defamatory and information which is true but confidential. And I think the better view is that that distinction is overly simplistic. And the reasons for that were explored in a subsequent English High Court decision called McKenna and Ash, where it was pointed out that drawing that kind of distinction would put the plaintiff in the very awkward position of having to fess up to which parts of the information were true and which weren't, and that would defeat the whole purpose of trying to protect confidentiality. So the view that the courts seem to have moved towards is that there may be some scope for the law of confidence to protect the disclosure of characteristically confidential information about a person, even if there are factual inaccuracies in that. And I think the other way of approaching that distinction is that there may be circumstances, particularly media circumstances, where a person, such as a journalist, has obtained confidential information about a person and they have used it to come to incorrect conclusions. So one could imagine a situation where your private emails or text messages have been leaked and the journalist has jumped to the false conclusion that you're having an affair with somebody. The proposition that you're having an affair might be completely untrue, but it's based on disclosure of confidential information, being private communications. So it could be regarded as fruit of the poison tree, and equity might intervene to restrict disclosure in that situation. What I think this discussion so far points to is that if you're going to court seeking to protect confidentiality, you need to be quite precise about the particular piece of information you're seeking to protect. I can illustrate this with an example from one of my cases, and obviously I have to speak about it in general terms so as not to disclose any details. But I had a case a couple of months ago where I was acting for a man who had been caught out by his wife having an affair. And the wife had obtained recordings of the man with the other woman. Now, the recordings, audio and video recordings of them speaking and even having sex, were clearly confidential information because they were recordings of private activity. But did that necessarily mean that the fact of the affair itself was confidential information? You could suppress the disclosure of the recordings, but not necessarily the disclosure of the fact that the affair was taking place. And there are a series of English authorities in this field which talk about the distinction between the confidentiality of what goes on in a relationship, what you get up to with your wife or husband or boyfriend or girlfriend, versus the fact of the relationship itself. And there may be a differential treatment of those two types of information. So when you're going to court in these types of cases, you need to be very precise about what you're trying to protect, and that will flow through into the way that you craft the application for relief from the court. The next thing you need to think about is how you prove that the information was imparted in circumstances which give rise to an obligation of confidence on the part of the defendant. So the information might be confidential, but if the defendant doesn't know or ought not to know of its confidential character, equity won't necessarily intervene to restrict the disclosure. Now, in some cases, this might not be very difficult to prove. The obligation of confidence might be inferred pretty readily from the nature of the relationship between the plaintiff and the defendant. So they might be friends, family members, spouses, and so on. This is likely to be a much trickier issue in cases where the threatened disclosure is by a third party, such as a journalist. And what you would need to do in that situation is be able to trace all the different means by which the defendant could have obtained the information and prove that the only ways in which they could have obtained that information would have involved a breach of confidence. It might be possible to infer that from the nature of the information itself. So medical records, tax and financial records, sexual type information are all plainly confidential on their face. And any person who comes into possession of somebody's medical records, for instance, ought to know that this is a confidential document and they need to treat it as such. But not all information is in that category. It might also be the case in these situations that the manner in which the defendant acquired the material involved some kind of statutory contravention. So, for example, in my case about the husband having an affair, the wife had covertly recorded him with the other woman. On its face, that involved a breach of the Surveillance Devices Act. And Section 11 of the Surveillance Devices Act makes it an offence to publish a recording which has been obtained in consequence of a contravention, or, importantly, any description or report of such a recording. So in a case like that, an injunction could run to give effect the criminal prohibition on publication in the Act, and you wouldn't need to resort to the equitable cause of action. The next thing that you'll need to prove is that there is some actual threat of disclosure. This may be difficult in some cases because you may not know precisely what information the defendant has. For example, in a case where a journalist submits pre-publication questions to you and you're inferring from those questions that they have something they shouldn't, you might be left to guess as to what specific information they've come across and how they've come across it. And so in advising a client about the availability of relief, you'll need to give some thought to how satisfactory the inference is that the defendant has particular pieces of information and how you would establish that. And you'll also need to think about timing. So is the threat of disclosure imminent or is it some way down the track? And that would affect whether you make an urgent application to the duty judge that afternoon or whether you give the defendant notice and try and engage in some process of negotiation. Whenever we're talking about injunctive relief, one of the things the court will look at before deciding whether or not to grant an injunction is the court will assess the balance of convenience. So even if you satisfy the court that you have an arguable case for breach of confidence, the court won't necessarily grant the injunction if the balance of convenience doesn't favour relief. Now, this may not be particularly controversial in cases where a lover or a friend or a family member is threatening to spill the beans about your client, but it may be a much trickier issue if the threat and disclosure is coming from a journalist and there's an argument that the story that the journalist proposes to publish involves some issue of public interest, in which case the court would have to weigh the public interest in disclosure of this information against your client's interest in restraining disclosure. The balance of convenience may also be affected by the strength of your case for suspecting a threatened breach of confidence. If you've got a very strong case that a breach of confidence is likely to take place, you might not need to show very much to satisfy the court of the balance of convenience, but if your case that a breach of confidence is taking place is weaker, you'll need to do a lot more to persuade the court that the balance of convenience favours relief. You need to think very carefully as well about how you craft the relief that you seek from the court. So, in terms of framing an injunction, you don't necessarily want to confine the injunction to a restraint on the disclosure of particular documents or particular recordings, but you might also want to seek a restraint against the publication of any kind of matter which conveys certain factual propositions or assertions which could have been derived from the confidential information. So, for example, I gave the example earlier of the client's emails or text messages being leaked to a journalist. You wouldn't just want to restrain disclosure of the emails and text messages themselves, but you'd also want to think about restraining disclosure of any story which might be published based on a description of what was in those documents or inferences or assertions about what those documents might prove. And just finally, I think whenever you're advising a client in this situation, you need to apply a common sense test. Is it really in the client's best interests to bring this case to court? And we've all heard about the Streisand effect, and that case was effectively a privacy case, or not a breach of confidence case, it was a privacy case, but it's a related area of law. Barbara Streisand was worried that photographs of her house in Malibu appeared on a website which was documenting coastal erosion. And the website had a few dozen views before she commenced proceedings, and within a couple of days, it had tens of thousands of views. When you go to court, it has the uncanny effect of bringing attention to issues, and that could partly be mitigated by seeking suppression or non-publication orders in an appropriate case, but those are not always granted, and you need to advise your client very carefully about whether the risks of taking action outweigh the potential benefits. So that's my overview of the reputational risk perspective, and I'll hand over to John now.
Thank you, Nick. I've approached this from the view of starting in my office and thinking about clients. Lawyers, of course, we live our lives in secrecy. It's part of our nature. Dick identifies that already by referring to a case, but careful to sanitise it, if I could put it that way, so not to disclose it. We're governed, I think, by a general approach, but also the terms of our retainer, which we all need to be careful about actually when we accept instructions from a client as to what we actually promise in respect of confidentiality. Our clients, of course, even relatively sophisticated clients, come to us with their own views of the world. That's what keeps us both entertained and busy. But I did reflect upon that at the various conversations I've had with people at different times talking about this issue of confidentiality and expressions that are used. We all understand the concept of confidentiality. The first issue is, are we having a transactional or a dispute conversation? And where does that lead us to? But the other things we come across are expressions that are common parlance. For instance, the expression commercial in confidence. I'm sure at some stage, regrettably a long time ago, a rubber stamp was handed out far too liberally, and many documents are now stamped with commercial in confidence. And perhaps when we get to discussion, I'd be interested to hear people's view, what does that in fact mean, and what obligation does it carry if you adopt that on a regular basis. Cabinet in confidence is another matter one has to deal with, and the obligations there. That depends. The Australian model at the moment is a 30-year obligation of confidence, subject to debate. But you have to be careful. Some of you may remember that when the federal government established the National Cabinet, it was drawn to their attention that that may not be a cabinet within the meaning of the obligations to keep the material confidential. And they found themselves in a position at that time trying to, after the event, justify cabinet in confidence to the discussions, which has an interesting view too at the time, having regard to COVID-19 was the topic that was being discussed. So you have to think about that carefully. Other times clients will say to you, and I'll defer to Nick on these issues where they run, but I've had an off-the-record discussion with a journalist, and they must have missed part of my conversation when I said it's off the record. Alternatively, I've used another expression, by background only. Now, again, non-journalists or people that don't deal regularly in the media, probably from watching American TV, after they've been read their Miranda rights, will offer those expressions thinking they actually carry some significance or legal binding nature. As I said, you have to think about that. There, of course, are statutory limitations on confidence, the Corporations Act, other specific statutes, the listings rules, another issue about confidentiality and what you're obliged to disclose, and the question, for instance, of drafting the infamous letters when you're acting for, say, a private equity company or somebody seeking to do an acquisition, the non-binding indicative only standard procedural letter to indicate to avoid disclosure, and the issues that confronts with boards. And another one I've come across is also a reference often when people are talking like we are this evening to assert a governing rule as to the conduct of our discussion, the Chatham House Rule. Now, every meeting where I see that's raised, everybody nods approvingly about the Chatham House rule. And I won't embarrass myself or anybody else this evening by asking what do we understand that to actually mean. It actually means different things to different people. And of course, that's the grist to our mill when people leave the room saying, I have no doubt about what we agreed, and they're diametrically opposed issues. So we need to think about those types of issues and then work out, well, what is it? How do we advise a client successfully? And you can Liam will identify the actual procedural issues and about the evidence, the opportunities to protect or avoid arguments. Precision, which I'm sure we'll all talk about, is one issue which we all compliment ourselves on, but that's one thing we need to clearly focus upon. A lot of my work covers a wide range of issues. Fundamental discussion I have with every client is a strategic one about what is our goal in this, what are we seeking to achieve, which may or may not involve a dispute resolution process, it may be documentation, it may be a whole range of issues, and also to be wary of those consequences that Nick's been helpful to identify about what goes wrong if you rush the court. A lot of the work I do is intellectual property, reputational issues, employment law, commercial consideration, and employment law is particularly significant. The protection and issues that arise under employment law are vital. If you think about the asset in play and the obligations that individuals have and how you regulate an individual's employment situation, for some time now, for some generations, we've been living through a very interesting opportunity that enormous wealth can be created in an individual. It used to be, when I was a boy, which is a long time ago, you'd have to create wealth by putting assets at risk. And you'd look for asset appreciation. These days, you can get a job, possibly not as a practicing barrister or solicitor, but we live in hope, and massive wealth can be accumulated by individual exertion. It's not unusual to see people who have earned $100 million in 5 to 10 years' time by having a good job and well-paid one. They're the exception, they're at the peak, but there are variations on that. And how you construct contracts, the information they have, how you protect it and how they protect themselves in contractual negotiations and possible exits are vitally important. Protective issues about if you're a prospective employer in contractual arrangements of ensuring that you don't get dragged in to a dispute over a breach of confidence by a new employee who thinks that one of the assets they bring to the equation is information they've acquired of their prior employer. And you have to think carefully about, and in my case now I think it's appropriate, for instance, standard provisions dealing with this type of issue in an employment contract. There are the usual ones, if I can put it that. We all have sent a precedent employment contract at the highest level. I am personally a fan of a deed poll in addition to that, because the contract itself has a relatively standard clause, but the deed forces greater particularisation and clarity and precision in your thinking about what is confidential information, what is it really all about, and also identifies to the parties the importance of this particular issue of their contract. Again, that's relevant also to the area in which they work and what you're actually trying to protect. Because when it comes to the transactional and documentation side, a conversation of what's truly confidential or unique or that you're justified in protecting, rather than a sweeping statement and having the, well, we go back to my rubber stamp of commercial in confidence, making a broad assertion which we would know would have the counter result. Standard form documentation always presents a problem as well. A lot of the work goes around when you go through the employment situation, you have the beginning, where you're negotiating the terms of the contract. What that means is preventative, it's trying to clarify what is about to go on. I'll come back to what happens in the middle in a moment. An observation there, directors often identify the most important the thing they do is hiring and firing a CEO. Occasionally it's necessary to remind them what happens in between is equally important. And we'll talk a little bit about that and how you deal with that. Standard form documentation of the deed, again, you should think about what you're really trying to protect and what is necessary in a deed. to give you the result and what you hope to achieve by it. The obligation of confidentiality is a little personal pet hate of mine. Still 9 times out of 10, rightly or wrongly, most people in the carve-out provisions fail to mention a spouse or de facto partner. It's been my experience by the time I'm having a discussion with a client who's on their way out, they've already discussed it at length with their spouse or de facto partner, and you can decide whether or not that's going to cause you any problem. But often casual conversations amongst family precipitate easy breaches. You're having a discussion about I'm going, or this is having to work around a dinner table, or casually the other people you're having that conversation may have no clue. Well, if they're having a conversation about it at a dinner table, that surely can't be confidential, or I shouldn't worry about whether I disclose that to anybody else. Linkage with non-disparagement I think is relevant. We can talk about that, how you package both of them up. So far as that's concerned, the secrecy of the terms and conditions of employment has now been avoided by legislative intervention. Again, I'm still seeing contracts where people are putting secrecy provisions and confidentiality provisions into an employment contract. That I saw one the other day, which still carried a right to terminate for cause if they disclose the terms of their employment, drafted by a well-known law firm. The Commonwealth Bank, of course, had that extensively and enforced it for many years until it's effectively been removed. But that's an issue there. The other thing in employment contracts is you may want your employee or oblige them to disclose what would otherwise be confidential information or private information that they hold in your best interest and in what you'd consider to be your reasonable interest. For instance, is there an obligation for an employee to disclose they're having a romantic relationship with another employee? Now, goes to the point that Nick sort of touched upon in his area about, well, the fact that they're having an affair as opposed to particulars of the nature of their affair, where they're having it or where there's been a recording made of it. But in this case, the employer myself, particularly if there's an imbalance of power, I'd require you to disclose that. You can stretch this as well, and there's no law on this, there's no been any decided decision, to say, well, I want to impose an obligation on my employees that they will disclose to me either that they've received an offer of alternative employment, or alternatively, having accepted, they must disclose it within a certain time frame. Now, one of the problems when managing internal confidential information, trade secrets and intellectual property, is people's behaviour after they've accepted alternative employment. Now, in the old days, you'd go down and check whether they've been coming on the weekend and running hot on the photocopying machine. These days, cyber security tends to play a more proximate relationship, or managing coming and going through security passes, which are now standard procedure. Once somebody's been given notice, if they've got to serve out or come back in, most organisations, having had provision in the contract, will more closely monitor their movements and activities, which can be done pretty aggressively and, in some people's views, intrusively with the technology that's available these days, from mobile devices, which are in fact owned by the company. That's the other issue. I always advise my clients to have 2 telephones, one personal and private, which maintains their number, and another one that they're given by their employer, that they use exclusively for employment work. And therefore, there's never an issue about confidential information breaches. But realistically, if you talk to cyber people, all of us, if you're not already alarmed by what they can do remotely to a telephone, should be. So you need to be aware of that, but you also need to understand an obligation. And there are a number of other things you can impose or seek to impose upon an employee, designed to say, well, if you've accepted an alternative role, possibly in breach of a restraint of trade, or possibly not, how do I know that they're going to continue to do the right thing? Yes, the duty of good faith and fidelity persists, of course, but people can behave in a very peculiar fashion. If I can bore you with one anecdote, early in my career, a managing director had had his employment terminated, and I might hasten, without my preliminary advice by the chairman, and I was brought in when the chairman said, I think we've got a problem. I thought it went really well. I said, tell me about it. And he said, well, he seemed to take it quite well, but then he left the building in the company car that he was provided with, which was Mercedes-Benz, and we've checked the photocopying records, and he appears to have gone through a couple of reams of paper shortly before he left. And he just phoned me to say the car is available for collection in the Domain car park, and I've thrown the keys and the ticket into the sewer. So as part of my expertise is I can now get a car out of the Domain car park, absent ticket and keys. So you never know. This was a CEO of a substantial company, or otherwise would have been observed as a relatively sane and straightforward individual. So you need to understand behavioural responses. If you think about a person like that who would have taken confidential information, the emotional response to it. So the other issue in the whilst in employment is the vexed issue of misbehaviour, and particular sexual harassment or sexual assault, and the increasing public scrutiny that's applied to the terms of termination or examination of individuals who've been involved in that. And as you would know, or should be, there is a trend now to disavow or disallow what are commonly referred to as non-disclosure agreements, both in Australia and in other parts of the world. I've had a look. I mean, Victoria's embarked upon this task. A number of the Canadian provinces have. California, in its own inimitable style, introduced a bill called Silence No More Act. And again, Joe Biden introduced federal legislation called the Speak Out Act, which seeks to mitigate against imposing compulsory obligations of silence on people arising out of those. Now, that's a very vexed question which is open to a number of discussions and the appropriateness of it. A number of people are seeking to deal with that, but it does highlight the whole issue about bringing precision to a document that reflects the facts and circumstances that are unique to the particular case. And we can talk about that too, because all those cases arise out of, or are subject usually to, some form of investigation that's taken place. So you owe a duty to both parties in that process as you're going through that. Both the alleged perpetrator and the alleged victim are entitled to privacy and confidentiality, in my view. But then the question comes when a determination is made. And with the greatest respect to some of the people that carry out workplace investigations, they don't necessarily understand their full duties and obligations. But that's an issue. The legitimacy of it's an interesting one if you think about it from advising corporations, a broader expectation under ESG as to what the corporation's role is these days, and the duty it owes to the infamous broad class of stakeholders. There has been some work done by a group called, some of you will be familiar with, the Champions of Change, who've looked at this very issue about how to balance it and make recommendations. But each company is now dealing with this, and what aspect of the determination of a workplace dispute is justified to full confidentiality? Should it be optional? So one needs to certainly consider that. The other issue, I won't go on too much longer, is I thought of a heading when I go to address this, which is the chaos theory, and which is the consequences of breaching any provision of an agreement, but what flows from that. Those of you who are familiar with the chaos theory is the butterfly flaps its wings in Brazil near the Amazon and a tornado erupts in Texas is the broad theory of that. There are a couple of other theories. My working model of that at the moment is PwC. A breach of a confidentiality agreement has consumed a multi-billion-dollar organisation and spread into a whole sector. And all of us sitting in this room are lawyers would contemplate, what is it you don't understand about the word confidential when entering into an agreement of that nature? Now, that's been the subject of an investigation by the Tax Practitioners Board. We've all seen, of those who are interested in that area, the participation before the Senate inquiry, and it hasn't ended. It has now got into the public domain as to a level of interest in that. Understanding the significance of entering into these agreements is possibly stating the obvious to everybody who's attending this session, but is something, somewhat interestingly, we have to remind clients of on a regular basis. The reason for that, one could speculate. Perhaps we live in an era where we're obliged to share everything on TikTok or Facebook or social media, whatever it is, there are no secrets. But that application is certainly of some significance. Obligations of statutory authorities are another issue. ASIC, for instance, is very keen to promote at the moment transparency and disclosure more fully, whilst at the same time it's fighting vigorously to refuse to produce documents to the Senate inquiry, maintaining the necessity for confidentiality and secrecy in respect of some of their files and papers relating to investigations. So they're some of the issues that touch upon my practice that I think are worthy of consideration. Interested to have questions or thoughts about them, but I've tried to think of this in the way that the issues that you may confront when a client walks in and talks to you about particularly important issues in their life and what they have to deal with. Thanks, Nick.
Thanks, Nick. When we were looking at this topic, one of the areas that came, I suppose, to me in particular was the question of the interplay between confidence and intellectual property. What we've explored so far really does relate to the concepts of information that is considered to be confidential. And when mulling around the input that I might be able to give into this topic, a conversation that I had with a colleague was about trying to look at what we might describe as the liminal space between confidence and confidential information and copyright and other intellectual property rights. That's because there is a fundamental difference between what is considered to be confidential information and what might be captured as intellectual property. And it's important to keep that distinction in mind when considering both the protections that you might be looking at either in contract or the remedies that you're seeking at law for either a breach or a threatened breach of either an obligation of confidence or a breach of intellectual property rights. It might be surprising to some that concepts of intellectual property infringement, and in particular copyright infringement, and what we all would understand in the modern parlance as being effectively piracy or the unauthorised reproduction of copyright material, is actually a lot older than most of us might expect. About 498 years ago, there was a publication by Martin Luther known as the Admonition to the Printers. And in short, what this was about was a complaint that even before he had completed the drafting of the apostles for the period from the Feast of the Epiphany through to Easter, a person he describes with a number of lovely adjectives, but in particular a knave, has come along, this was a typesetter, has taken the manuscript, arranged for it to be printed, and he's found a draft of his own apostles out and in circulation before they were even completed. Now, interestingly, this might seem to be an interesting historical aside, completely divorced from what we do today, but the issue of the complaint was one of reputational risk, that the draft hadn't been completed, it wasn't at the standard that Luther had expected of himself. And so there was a question of loss of reputation as a result of the unauthorised reproduction in material form of what was a literary work, which is the infringement of the copyright. There was a question of the misuse of confidential information, to it being the draft that was never intended to see the light of day. But at the end of the admonition, to all and sundry, Luther says, in effect, all of our readers should know that we use a unique typeset, and you should only trust the books that have our unique typeset. And it's not exactly digital rights management, and it's not exactly a level of anti-counterfeiting technology like we see on perhaps our modern currency, but the concepts were there. That predates, for example, the Statute of Anne, which was where, at least in the Australian system, our modern law of copyright really takes its origins. But the concept of a complaint like that so far back in history made me realise that these are not concepts that are particularly unique or new to our world or to our information age, but they've really been around in very literal terms since the development of the printing press. So what I was looking at here is the fact that whereas confidential information is somewhat vacuous. It's defined by the quality of the information possessing that necessary quality of confidence. Intellectual property is something that is vastly different. It's defined by, for the most part, statute and particular exclusive rights that are afforded by the state for a fairly defined public policy purpose. For the most part, those exclusive rights are afforded to the authors or otherwise the owners of intellectual property in order to assist in the development of cultural or technological ideas that are ultimately given to the public and enter into the public domain after a period of time. So the granting of exclusive rights or the granting of a limited monopoly to exploit those rights is done in order to allow for an economic return to individuals who have toiled and employed the creative spark in order to create those works. And it's done in order to ultimately allow for a balance between the protection of the monopoly of the person who has created those works and the benefit to the public of being able to take the ultimate benefit of those works when they enter the public domain. What that means is that there's a bit of a tension between the concept of confidential information and most species of intellectual property, given that the fundamental aspect of confidential information is that it remains confidential. Whereas for most species of intellectual property, the fundamental aspect is that it is ultimately disseminated, whether it's published or whether it's used or exploited, or whether it appears on a publicly available register and is explained in such a way that anyone can ultimately reproduce the steps required to either create it or to utilise it, as in patents or design registration. So we wind up in a position where it might be thought that there is a tension between the protections you gain in looking at actions for breach of confidence and the protections that might be afforded as exclusive rights to a person who is the owner of intellectual property. But it's not necessarily the case. A matter that Nick and I had spoken about, which again, drawing back into history, sometime earlier this week, was the matter of Prince Albert and Strange. Now, I'm not going to do the matter justice by talking about the detail of the proceedings, other than to say that this involved the threatened publication by... actual publication by Mr. Strange of a compendium or a catalogue of lithographs that had been shared between Queen Victoria and Prince Albert. The complaints related to a breach of confidence or misuse of confidential information, and ultimately the Prince was entitled to an injunction to restrain the publication of the catalogue. Now, there's quite a bit in the steps as to how those lithographs ultimately wound up in the possession of the defendant in those proceedings. But what was ultimately relied upon was the concept that not only were they themselves potentially confidential, but that they were a form of property, and that it was appropriate that an injunction be granted to restrain the publication of them in circumstances where they couldn't explain how that property had got into the hands of Mr. Strange, other than potentially through improper means. Moving forwards in time, threatened infringements of intellectual property are subject to the ability for the owner to seek an injunction to restrain those potential infringements. And one of the matters which we all probably are used to referring to in certain contexts actually relates to a commercial dispute that related to the threatened infringement of copyright and disclosure of confidential information in respect of computer technology and computer parts. That's the matter of Anton Pillar and manufacturing processes. Now, we're all probably familiar with the concept of what an Anton Pillar order is, but what had occurred in these proceedings was that the English company that had an arrangement with Anton Pillar for the importation of the particular computer part, and the name escapes me now of the particular part that was manufactured, they had been entering into negotiations with other entities to reproduce those parts and in effect do away with the need to import them from Anton Piller, who were the original manufacturers of those parts. The order was obtained not only because of the concern about potential infringement, but also the real possibility that evidence was maybe removed or destroyed if there was warning that was given to the English entity that orders might be sought in that area. Now, ultimately what the case was about was the misuse of confidential information as to the design of that part, and also the breach of the intellectual property being the copyright itself at that time in the design. What ultimately occurred there is not subject to a published decision that I've at least been able to identify, but the two causes of action were hand in hand, in effect, that there was an alternate pathway under infringement of intellectual property rights, to it copyright, and also a question of the breach of confidence by a party that had received information that was of the necessary quality of being confidential information, and in circumstances that gave rise to that obligation. So these two different concepts, especially when it comes to copyright, can flow together and can be quite complementary. There are other ways in which parties have attempted to use the exclusive rights that might form part of a claim for example, copyright or other intellectual property to try and assist in the restraint of the distribution of confidential information. And that has particularly arisen in a couple of matters that relate to attempts by, for want of a better term, advocates or vigilantes, depending upon how you might see them, to highlight the cruelty or potential cruelty to animals that occurs in farming practices or in abattoirs and similar. One particular matter, which was actually a first instance decision in the New South Wales Supreme Court, was the matter of Windridge Farm in Grassy. In that matter, what ultimately occurred is that activists were able to obtain unauthorised access to a farm. They took videos of the conditions in which, if I remember correctly, pigs and sows were being kept in that farm. And that information was ultimately supposed to be used for an investigation into the conditions that those animals were being held in, but ultimately made its way out into the public more generally. An injunction was actually sought in that matter and declarations sought as to a constructive trust arising over the copyright in the property in the video recordings themselves as a method of preventing the dissemination of that material. That is, the owners of the farm were attempting to use the nature of the confidential information of being embodied in a copyright work as a method of being able to obtain ownership of, or at least beneficial ownership of, that property to restrain its use and its further dissemination. Now, the injunction was sought but not given, but it does indicate that there are methods in utilising the nature of the property itself and potentially its embodiment within intellectual property to gain access to remedies that might not otherwise be available when the information is considered under the concepts of a duty of confidence only. The intent of this is to try and provide some ideas as to how to, or what considerations you might need to have when you're thinking about potential causes of action, but also what remedy you might want to seek. And moving into just a quick response to John's discussion about the risks that employees might ultimately cause to a company and what it is that they might do with respect to confidential information. One of the concerns that you may have is that when an employee does potentially make off with confidential information or remove intellectual property from a business, you have to be very careful about the remedy that you might seek and the proportionality of the proceedings that you bring. The outcome that you ultimately want is one that obviously protects the nature of the business itself, but you need to consider very carefully whether or not that's going to be achieved and what actual damage or reward might be given by the court in response to either the breach of the obligations of confidence or the infringement of the copyright. In about 2013, there was a matter of involving SAI Global, the information brokers, and an employee who ultimately took client lists and took information relating to the products that he was dealing with as a salesperson to a new employer. The reason I raise this matter is only to consider the proportionality of the proceedings and the remedy, because ultimately SAI were successful in both proceedings for breach of contract and breach of the duty of confidence that was included in the employment agreement, and also proceedings in respect of infringement of copyright. Now, while there were some additional damages of, I think the sum was about $5,000 awarded, the copyright infringement damage award was only a single dollar. It was nominal damages. And the breach for the breach of the employment contract only netted them back, I think it was 2 weeks' wages. The proceedings themselves and the costs of the proceedings ultimately outweighed the matter by a multiple, and the court did have something to say about the way those costs should be apportioned. Ultimately, looking at the outcome that was achieved, it's not necessarily one you might look at and say that that was a successful outcome, even though the orders for the court were in favour of SAI. So I suppose just in brief, to recap, these issues are not new issues. These are issues that can be looked at under different lenses, and one lens is the proprietary rights that can be afforded under, in particular, copyright, but intellectual property law more generally, as well as the remedies that can be sought, both for breach of confidence, whether that's breach of confidence under terms of a contract, or whether it's the obligation of a breach in the absence of a contract, and the statutory remedies that may be available under, for example, the Copyright Act, but in respect of intellectual property more generally. Hopefully that's given a couple of thoughts as to either questions or at least spurred some ideas as to what you might consider when looking at those issues. Nick?
So there's time for questions, and if anyone has any, they should indicate their desire to ask them in the appropriate fashion. Matt?
Liam, thank you very much for that contribution. There's recently been reports of authors being upset that their publications are being used to train AI bots like ChatGPT and the like as language models.
Yes.
And they're getting upset that although they've published these things to the general public and to the world, they don't want them used in particular ways. Is there anything that can be done in the context of confidentiality to address something like that?
That's a fantastic question, because it's one of those ones which not only is it topical, but it's very difficult to answer because of how new the area is. But again, these new concepts and the training of large language models and what we're calling generative AI, using intellectual property, or using, in this case for the most part, literary or artistic works, is something which is not necessarily all that new. Ultimately, what is occurring are that the developers of these systems are utilising very large bodies of works that might be available publicly, and so they may not. And in fact, in almost all cases, I would assume that they do not have that necessary quality of confidence, because that information is not private information, it's not being kept confidential. But in a very large part, that information is it's published subject to particular terms. Most websites will have what I think we all can refer to as the annoying click box, or otherwise the link at the bottom no one reads, which would be the terms and conditions of use or access of the site. The intellectual property that resides on those sites, in the most part literary or artistic works, is provided pursuant to those terms. Now, there's a wonderful discussion we can have about the validity of those terms on particular sites and why it is that annoying pop-ups might be required to bring to your attention the particular terms used. But ultimately, this is a question of licensing, and it's a question of whether or not the entities that are utilising these texts have been entitled to do so under the terms of the licenses that have been available. This is also something that's come up previously, and for more than 20 years, search engines have trained their algorithms on the basis of information that is available publicly online. And after some hits and misses, there seems to be a general position that small files known as robot texts that sit on servers will direct whether or not a website provider has given permission or consented to the indexing of that information for a search engine. I don't personally see why large language models couldn't have a similar regime whereby if people wished for their information not to be crawled or indexed by a large language model or included in a corpus, they could indicate that. But the real difficulty is that somewhat puts the cart before the horse. And the bigger question is, shouldn't these large language models, the developers of these models, have sought permission or sought a license to use that information in that way? It's not a question I can answer, but it's definitely one that we're going to see more about.
We've got an anonymous question. To what extent do the principles of breach of confidence apply to disclosures of information that are not deliberate or proactive? E.g., when the party holding the confidential information and who owes the confidentiality obligations does not themselves actively disclose the confidential information, but instead another party gains unauthorised access to that information. The questioner goes on, my thinking is that this does not amount to a breach of confidentiality, which I think connotes some proactive disclosure, but I'm interested in the views of the panel.
This may or may not be a direct answer to your question, but the classic law school problem is a person has a confidential document sitting on their desk and they have a fan on their desk and the fan blows the document off the desk and out onto the street and somebody walks past and collects it. I had this experience personally a week or two ago when I live near St Vincent's Hospital, and I was walking past the hospital and looked down and saw something which very much looked like a medical record on the street. And I did, I have to confess, stop to read it. But what would happen in a situation like that where the original confidant allows the confidential information to get out into the wild and it is picked up by a third party who uses it? If the third party is or ought to be on notice of the confidential character of the information, he or she is subject to the duty of confidence and can be restrained from using it. It depends on whether the third party is on notice of its confidential character. As for what information, what action could be taken against the person who perhaps negligently lets it out into the wild, I don't see necessarily why an actionable disclosure of confidential information couldn't be negligent rather than intentional, but I can't think at the moment of an example of that in the case law. But I think certainly if through some negligence you allowed confidential information to be disclosed, even disclosed by a third party, you could in principle be liable for that. A question which might arise is whether the action of the third party in disseminating the confidential information broke the chain of causation, so that although you were negligent in allowing it to get out, you're not causally liable for the consequences of the disclosure because the third party's act was an intervening cause. I don't know if other members of the panel have different views about that issue.
Probably only one thing to raise, which is that what we're talking about here is distinct from the obligations that, for example, large companies and in particular, and what's been topical recently is probably large health funds have when it comes to the protection of privacy and personal information and health records. The idea that a negative actor, someone who has deliberately and knowing that it's wrong, gained unauthorised access to a database of information, for example, can bring questions as to the liability of the organisation as to whether they had appropriate security regimes in place. I think that's something that's probably beyond the scope of what we're talking about here, but certainly there are obligations that do affect entities in that regard, and you can't assume that simply because the disclosure of information you are holding, which is confidential, occurred because of someone else's actions, that you would be free from liability. Quite the contrary. It's really going to depend on the nature and circumstances of how that person gained access. And as Nick says, negligence is one area, and there are some statutory protections that are beyond the scope of, I think, what we've looked at today, but certainly things that need to be considered. Consider also the necessary for disclosure of any data breaches that do occur, and that's something which we've seen play out, unfortunately, between Vodafone and between others in recent times.
I think the only other observation there, of course, is the regime that the disclosure seeks to impose upon the recipient, so far as safe custody and procedures, and they vary dramatically depending upon the circumstances, even down to sometimes a prohibition on electronic transmission of information that's been provided to avoid a inadvertent send CC all.
I don't have any further questions.
Oh, Jackson does, however.
Question for John and the panel more generally. So to go back to the employee case, and I'm just wondering whether you have any experience with innovative ways of, on behalf of the employer, uncovering evidence that a former employee is in fact acting in restraint of trade, is breaching some obligation of confidence, because it's often the sticking point that you may have sent the letter and the employee or the former employee has sent back a letter saying, yes, I give all those undertakings and I'm willing to abide by the conditions of my contract and I haven't taken any intellectual property, but there are strong suspicions that things are happening underneath the surface, and it's always that difficulty, and the other panel members may have some experience of this as well, of actually proving it. So I wonder whether you have any sort of innovative or particular examples of where that's taking place, that sort of uncovering.
I don't know if it falls into the category of innovative, but clearly one of the major concerns these days is the new employer being dragged into litigation. And the obvious thing to do, and I've done that on a number of occasions, is join them, provided I've got a reasonable basis for doing so, and raise that issue fairly and squarely. That often has two consequences. One, it identifies the fact that you now have a defendant of substance against whom you may be able to recover. Alternatively, it leads to the termination of your former employer. The very simple proposition is, well, if they've stolen from their past employer, they're inevitably going to do the same thing to me, and it leads the current employer to question that. And I've spent a lot of time drafting clauses for the new employer about dealing with, we only employ you, we're not interested about the information you bring. That goes also to the effect of inducement of breach of contract of this environment too, where you get, for instance, the establishment of the investment bank Barrenjoey took at least 3 tries to get off the ground because they kept on getting stopped or were threatened of a stop action by the current employer of the people they were targeting. And they eventually got it right. And there is a checklist available of things you should not say or you should say in the course of the interview process. And it's not unusual, in fact, have a warranty by the prospective employee as to what they're bringing and that they haven't breached their prior agreements. On the other hand, the contract of the employee requires them to disclose to their prospective employer that they are the subject, and you are both obliged and entitled to disclose the relevant parts of your current employment contract to any prospective employer. And you can also say, you must do that or inform me. Comes back to my point, I've actually drafted clauses where you must notify me as your current employer within 24 hours of accepting alternative employment. So I'm at least alive to the issue. So you can have an argument, I mean, people can occasionally argue about the validity or the enforceability of some of those. But there's also, by doing some of that, an obligation to advise you and confirm. So you say to your current employee, not only will you disclose the restraints and obligations that you currently are bound by, you will then write to me and confirm that you've done that. And that gives you another opportunity to seek a specific performance order rather than a restraint order. And this whole purpose is designed to make life very difficult for everybody to seek to protect it. So whether that falls under innovative or just traditional approach by lawyers, there's some of the things you can do and think about. And the reality is most prospective employers don't want to get sucked into litigation. I mean, nobody's indispensable. And as I said, their view will be, if they've done this before, they may well do it to me. That is some assistance.
Probably one small anecdote I can add to that. I had the great misfortune at one stage on behalf of the client to act for a gentleman who had ceased his employment with one entity and after a reasonably appropriate period had taken up employment with a competitor entity, believing that he'd made a clean break and believing that everything was entirely appropriate. He then bought a house. Whereupon the old ex-employer came down on him like a ton of bricks. And it turned out that when you're talking about innovative ways to gather information as to the compliance with undertakings, John had previously mentioned the wisdom of having two separate phones, a personal phone and a work phone. And this gentleman did that. He took that advice and he followed it, and he had two separate phones, a work phone and a personal phone. But he backed up his personal phone to his work computer. And so the years of SMS messages about the information he'd take, when he'd leave, how he'd do it, and the maximum damage he'd cause to the competitor with the new entity were fully available. And it was somewhat a little embarrassing to go through the level of detail that they had over years and years and years. Because once they'd realised what he did, of course, they still had his old computer. And all they did was looked through it and discovered, honestly, about 2 to 3 years worth of correspondence that they'd been setting this up. So I suppose the only thing I'd say is that there are backups that people take of their information and they think that that's for their own protection. And at times, perhaps it's useful to look at the digital trail.
Yeah. And you shouldn't assume cleverness by all former employees either, because I've seen the same thing done exactly, but without the imposition of a private phone. They've simply used their work phone, and even the point we once found communications with a graphic designer designing a letterhead for a competitor business that this employee and some other colleagues were about to start upon leaving.
I had a guy using his work email to send across the client list to the new.
That's right. Well, they suddenly download everything that's on their hard drive at work send it to their Gmail account. And surprised when they get a tap on the shoulder.
Well, wasn't there a case a few years ago where I think it was a BlueScope employee was in the firing line and she kept putting off her termination meeting, saying that she had work to do, and she was caught with a USB stick plugged into her computer, just downloading everything on it. And the reason she wouldn't attend the termination meeting is because the download was still taking place and she was waiting for it to finish.
It's amazing the records that you can actually pull off a computer in terms of what USB keys have been used and the like. And if you ever get a letter asking for delivery up of USBs with serial numbers X, Y, and Z, you can assume that the information's already in the possession of the other side.
There is a particular consultancy I use in this work that can basically just about recover or discover virtually everything.
And on that thread,
We're all going to get a little more nervous now.
Yes. I'll read all your emails tonight, don't I?
I think there's no further questions from me, but I know we had 2 questions that came in prior. I'm not sure if you've addressed those.
Oh yes, I was going to deal with that.
I mean, both of these questions, I think, intersect with statutory regimes which are not, at least within my area of expertise. And as I said in my little spiel, I think it's important to distinguish between the area of protection afforded by particular statutory regimes and the general law in relation to protection of confidential information in equity. I don't know if other people have more constructive responses.
In short, I'd say from my side, not a great deal more constructive response, but I should indicate that this is an area where the question is quite specific as to, and just for the benefit of the room, the questions we're looking at are, given the current trend for information collected by companies to be stored on servers overseas, what steps do we as a panel realistically believe are best taken by a business with an annual turnover of more than $3 million to limit their liability for data breaches? And then the second question, which follows along from that, is that if a not-for-profit in New South Wales solicits donations for their cause, which are erratic, i.e. not likely but possible, if there's a serious drive for donations, they'll receive donations that exceed $3 million. Is it wisest for the not-for-profit to assume this will count as turnover and it will be obliged to comply with the Federal Privacy Act? I think there are elements of this that really require specific advice as to the obligations under the Federal Privacy Act. But as to the second question first, where there is a particular level within the legislation at which you have to start complying with the regime in a more serious way, if I can put it that way, or where there are higher obligations for companies with turnover of in excess of $3 million, I would say that it is absolutely wisest that the not-for-profit considers their obligations under the Federal Privacy Act and the steps that they need to take. Because the difficulty, just on a practical level rather than a legislative one, is that the processes that would be required to be put into place in order to ensure compliance are certainly not going to happen overnight, and they're very hard to bring in retrospectively. So if, for example, you needed to consider where your data was stored, if you needed to consider the level of authentication to access data, all of these things, just on a business interruption point of view, are matters which are going to take some serious doing. And so unless there's a very significant impediment to putting them into place early, if there is a possibility that the regime may apply, it is certainly something that you'd be thinking about in advance and something that you'd be looking at early on, just at a practical level. But I stress, I don't think any of us on the panel, John, I'll defer to you, would be able to...
No, look, I think you're right. It's two very specific questions, but I agree entirely with you, and it's better to be preemptive in that case, rather than scrambling around at the end and not only trying to solve the immediate problem so far as your clients or your customers' concerns concerned, but dealing with the regulator, maybe having a view that you're in breach of the law, as opposed to also dealing with the commercial issue. So if in doubt, I share your view.
Do we have any further questions from the floor? I think that's it.
Thank you.
Well, thank you.
Thank you so much.
Thank you.
Thank you.